those are specifically put on by the developer.
Yes, our ordinance requires that they hold the meeting and take the minutes for that meeting.
Well, I'll start off with a premise that there is no law that says that you cannot attend. But the public policy of the state is opposite of that. And as your lawyer, I'm delighted that you don't attend. The reason to have that meeting and the public policy is that gives an opportunity for the developer to expose his plan to the community and adjoining property owners, have a discussion, a free and open discussion, free from any kind of intimidation. And I say that not that elected officials are intimidators, but just your presence could have a chilling effect on people asking questions to the developer. It just goes with, it's the nature of your position. So it is better under public policy that elected officials don't attend so that there is a free discussion. And the result of that is a lot of times a developer will change his proposed plan, amend it to take into consideration the comments that he or she received from the community, so that that's before you ever see it. It's to give them that opportunity to have that dialogue and those opportunities to make a change to the plan to conform to what the neighborhood would, like to see adjusted. So then when it comes to you in the form of a petition, your chance for discussion is the public hearing. That is your opportunity to discuss with the developer the pros and cons of the development. But one other factor that I think is important, and that is the zoning ordinances, whether it's approving a plan or approving a rezoning, or if it's an ordinance that denies it, is subject to judicial review. But the theory behind by being glad that you don't go there is, if you go and start participating in this plan development progress, and you all of a sudden are on the sides of an opponent or a proponent or an opponent, either one, you now create a potential bias, even before there's a public hearing. And how a court would react to an elected official being biased on a conditional zoning vote. There are cases about bias, but those obviously, most of them were involved with the quasi-judicial, but there is bias that can be brought up, and you never know what a court's going to come down on to come up with a decision that it wants to make. And that can be used against the adoption of the ordinance, whether it was approved or denied. Either way, they can either outright reverse it and grant a permit if you denied it, or alternatively, they could send it back and go through the whole process all over again. Don't give as a lawyer, I'm telling you, don't give the court some fodder to to reverse an action that you've taken. Either way, don't give them that kind of fodder to be able to say, well, it was obvious the majority of this board was biased.